Okay, I have 7:02, so we'll call to order meeting of the Zoning Board of Review, North Smithfield, January 10th, 2023. Roll call, please.
Mr. Najarian?
Here.
Mr. Martin?
Here.
Mr. DeZio? Here. Mr. Mark Antonio?
Here.
Mrs. Burlinghoff? Here. Ms. Benoit? Here.
Okay, just to clarify, we welcome a full board now. Mike is traveling, so we have Chris moved up, so we have to get your nameplate revised. And we have two alternates, so Gail is the number one, Bethany is the number two. So Gail will serve as, to fill Mike's spot for everything that occurs today. Welcome, well, to our new member, and welcome to our returning member. Okay. Item 3, disclosure of no compensation or pension credits received by the board members. We serve at the appointment of the town council and receive no compensation. Item 4, disclosure and notice. Zoning Board of Review members shall disclose any ex parte communications and any contested or material adjudicatory facts or opinions concerning the merits of any application before the Zoning Board of Review. Item 5 was the approval of the minutes of December 13th and December 19th. Why don't we go to the 19th first? I think those were sent out in plenty of time. So unless, does anyone have any revisions or corrections they'd like to request?
No.
Hearing none, do we have a, no,
I'll
that's
ma-
wrong day.
I'll make the motion.
Wrong day. I moved to the 19th first, Vinnie. We'll come back to the 13th.
I'll make the motion to approve the.
Okay,
minutes for
we
the
have a motion,
discussion.
Mr. DeZiel, second from Mr. Martin. All those in favor?
Aye.
Okay, opposed? Now, we also have the 19th. So there may be some confusion. Mr. Mark Antonio had distributed a clarification. Tiffany, I don't believe, was that ever added to the minutes?
No, it's just distributed.
Yep, it's up to
Okay.
you all tonight.
Okay.
Yep, Mr. Mark Antonio asked for clarification on page 4, and I provided that to him, and I provided that to the rest of the board to discuss tonight.
But that's just clarification of what the application, how the application reads, right?
It's clarification on what was deliberated
Oh, okay.
on the 13th.
All right, well, why don't we do this? I may be in error. I don't know if other members are. I did not, I was not paying attention. I did not give it the attention that it deserves. I think we should continue this to give members a chance to understand it, and then we'll bring it up at the next meeting to approve. Is, for the solicitor, is that an issue if we continue approval of meeting minutes?
Do we have to
Okay.
make a motion for that?
I think we should. Do all agree? I mean, I don't want to, we need to give it the due diligence that, and if we didn't, it's not a big issue. We can just continue it.
I just have a question, Mr. Chairman, because
ahead.
I was not at that meeting, so I don't even know how to.
Well, then okay, well, if it doesn't, read it, and if you have a specific question, you're certainly entitled.
Okay.
But as it relates to whether or not it should be included, that can be debated by the members that
Okay.
are present. So why don't we do that then? Why don't we make a motion to continue the approval of the meeting minutes from December 13th?
I'll make a motion to move the approval of the minutes for December 13th to the January 24th
Correct.
meeting.
The purpose is to review the addition or correction or clarification submitted by Mr. Mark Antonio. Do we have a second on that?
I'll second
We
that.
have a second. All those in favor?
Aye.
Aye. Any opposed? Okay. And we'll give this the read that it needs. Okay. We have 3 items on the agenda tonight, so bear with us. New business, item 6A is ZBR application 2301. And this is application for dimensional variance by Andrew and Amber Lizotte, 120 Andrew Street, Woonsocket, Rhode Island. This is for lot APO 8, lot 39. Excuse me, is a non-conforming lot of record. The lot does not have enough frontage along a public road. Applicant is seeking relief from section 4.2 of the ordinance, which requires a dimensional variance. The lot is a RA 65 district. Applicant would be constructing a single-family residence with an in-law. The applicant here, I was told that your attorney has COVID and will not attend?
No.
Okay, so,
I was gonna be doing it, but, I was cleared by my doctor earlier today, so I'll be able to present it with Mr.
oh, I misunderstood. I thought you had asked for a continuance, so that's what I was prepared to do. But are you the counsel?
I'm the surveyor who's gonna be giving the presentation.
You don't know Norman?
Okay. What's that? All right, well, no, if you're here and you want to proceed without your counsel present? Okay, and if we need to continue it, we will. So let me do this. You can sit back down again. All right, we won't be prepared. I know I won't, because I was operating under the impression that you weren't presenting, so all of the work that is preparatory to that wasn't done because it didn't need to be done. So we'll have you make your presentation. The board can ask some questions. I know in my mind there was things that needed clarification, so I think it was going to be continued no matter what. But this way, as the professional surveyor, most of it lays in your lap anyway. So I'm going to introduce your articles or your submissions, and then I'll call you up. So P1 will be the application, the generic standard application of the zoning, building and zoning official. Again, it's ZBR 2301. It's dated 0/10/23 for this meeting date. It's the complete application. 11 pages with the addendums or the attachments for the variance or the special use. P2 would be a warranty deed was received by the town. It's a 1 page, 2 pages. Received by, recorded on 4/5/21, and this is the warranty deed, Richard Carreri, and which is relative to Amber and Andrew. That's P2.
I just want to clarify something, Mr.
Sure.
Chairman, because I got 2 warranty deeds.
Yeah, I made them separate.
Oh, okay.
So this is just the first one that's copied on both sides.
Oh, okay. Gotcha.
P3 would be the easement agreement received it for record on 3/4/2021 at the town North Smithfield Clerk's office. Easement agreement between Robert Lizotte and Deborah Lizotte, 102 Brentwood, and Richard Carrera. That's P3, and that's 2 4 pages. P4,
That's not for that one.
yeah, Brentwood, yeah. P4, I'm not exactly certain what it is. It's pages that show lots and generic writing and some subdivision paperwork from 1967, when I believe the Brentwood Drive subdivision was filed. So that's there's quitclaim deeds involved, so I didn't count it. You can give me a count.
17 pages.
17 pages for P4, and those, some of them are double-sided. P5 is of a similar age, it appears. Let me open it up. It's a single-page sheet. It's a plan showing proposed subdivision for Brentwood Drive, and this was accepted on the August 28th of '67.
Is that the document that's stated in the lower right-hand corner, August 29th?
Correct,
Okay.
correct. And we'll call that P5. P6 is the other warranty deed. I just want to make sure it's not the same, but I don't think it is. It
No,
was-
the other one's 11 o'clock.
Yeah, okay.
Yeah, one
So this other warranty deed is P6, and that's, was recorded North Smithfield on 4/5 of '21. Why does it look
It is the
similar?
same.
It is the same, that's what I thought.
Yes, it's the
All right, so disregard this second warranty deed with a 4/5/21 recording date is the same as the previous.
P2.
So
Yeah.
P2, so I'll have to rework, so we don't need this one. So the next one would be P6 instead of 7. It's again, it's this document for all the members.
okay.
It kind of, again, this is 3 pages, which is a bit cryptic in what it's trying to, I believe this is portraying what was the easement or what was reported as some kind of cart path or some such thing. So that's a 3-page document, and again, it has no title to it, but we'll call it P6. P7 is what was presented by O'Hearn Associates. It's basically just schematic drawings of architectural showing what a proposed house would look like. It's, I think it's 4 pages.
5.
5 pages.
Can we add that it was dated July 13th, 2022?
Yep, that's fine, my mistake. Yep, the date on that, on P7 is July 13th of 2022. It's just it's architectural.
Yes.
P8 would be the boundary survey, which was prepared by national, or professional, well, they changed the name, so it's not national anymore. It's, yeah, it is, National Surveyors and Developers. It's stamped by Norbert Therian, registration number or license number is 1739. He initialed it, signed it on 1/12/21, and this shows the boundary survey for lot 39, AP8, and AP8 lot 44, and the historic path card. I highlighted mine, so.
Right, is that also the document that contains,
Correct, that has the
an
wetland.
application
yeah,
for,
yeah. It has the DEM record on it for receipt. Oops, sorry.
It's your OWTS.
Yep,
okay,
and then the next page is it says OWTS, and then,
Do you want to put the date, reference the date on that? Or is
no,
it-
no, I gave the date. No,
These
well,
are all
no,
different dated.
I don't think so. It's all part of the same document, so. So yeah, that's P8. P9. P9 appears to be the 200-foot radius map. It's, again, stamped by National Surveyors, Norbert, again, registration is number 1739, and that's, his stamp is signed and dated on 10/31 of '22. So that's it, that's everything that was introduced.
the only thing that I recall trying to take a look at, maybe it's contained in I'm gonna say 4. There was a, document that was recorded when this area was part of the town of North Smithfield. It was a handwritten, document which, purported to be the original right-of-way to the property? Is that where that's contained?
Yeah, it's in P4.
It's in 4, yeah,
Okay,
that multiple page document, yeah.
You could read that?
no.
Yeah, not the easiest thing.
No.
Yeah, you can.
Okay,
I'm gonna leave that to the historical researcher of our
if
committee.
the applicant surveyor would like to come forward to the podium, raise your right hand and follow the instructions of the secretary. Just one at a time for now. Let him make his presentation, and then you guys can come up as we need you. We don't have a stenographer, so just indicate your name, your profession, I guess, and indicate that whatever your testimony will be truthful to the full extent possible.
Good evening.
You have to state your name.
Norbert A. Therian, T as in Tom, H-E-R-I-E-N. I'm a professional land surveyor and worked with the applicant, Andrew and Amber Lizotte, with regards to the submission to the zoning, to have the application reviewed and hopefully accepted, and allow the proposed construction to take place. I have a resume, and if in turn you wish, I can hand this in to you.
Well, that's fine if you'd like. We've seen your name for years, so we know, I think all of us are well-versed on your professional integrity, but you
Thank
feel free to submit.
Well, that means is that I'm old.
I prefer the phrase less young, Mr. Devoto.
I don't know, after a while, it just gets old. Andrew and Amber purchased a lot number 39 on Assessors Plat 8, which is located on the westerly side of Brenton Drive. It's an 8.43 acre parcel, and it is zoned in an RA 65. This particular piece of property, as well as the abutting property that is now known as the Woonsocket Hill Estates, this was 2 large tracts going back to 1862, when North Smithfield and Smithfield were the same lot. And at that time, they granted to each other, to 2 farmers, granted to each other the ability to pass and repass across each other's property to get to the public road, which is Woonsocket Hill Road. And that's that old deed, book number 34, page 382, I believe, the one that's handwritten that you can hardly read. And I've had to read it several times to understand it, where they grant to each other the ability to pass and repass to get to the main road, the public road. And eventually that created the cart path that eventually, when Brentwood Drive subdivision was proposed and Brentwood Drive itself was created, that path and right-of-way is shown on the plan. And if you take a look at one of the plans that I gave you, which is a couple of copies of the subdivision, well, Woonsocket Hill, you'll see where I've highlighted the cart path, and it says access to highway. That'll be the old plan. And that's how that plan appears in the vault. So, I can't tell you exactly what every line means, but in a nutshell, this piece of property had an ability to get to the public roadway, originally Woonsocket Hill Road, and then when Brentwood Drive was created, they purposely made a statement on that plan in 1966, which eventually was accepted in August 28, 1967, that this particular lot, lot number 39, would have access to Brentwood Drive, which is then and is still now a public roadway.
If you could, I mean, as complex and arcane as some of this may be, or is, I mean, when it's all said and done, we need to pare it down to the basic facts that pertain to today and what is being requested. So, one thing I was a little confused about, and you can continue in a moment, I just wanted to get clarification. On P9, which appears to be, that's the radius map,
Yes?
I'm confused. Who owns 39 and who owns 144? Does the applicant
30
bought 144 or they bought 139?
144 is owned by Mr. and Mrs. Lizotte's parents,
So that's your parents that are at 144.
that on lot
Okay.
144, that's
So the
correct.
larger property, which is the 39,
39
which you indicated is the 200
is
radius.
the yellow,
Okay.
the hole in the doing it, yeah. Right.
And
The
who-
Lizottes did not participate at all with regards to the creation of the subdivision back in 1966. The lot lines were created back then. They've subsequently have purchased, the parents purchased lot 144. Obviously, their desire is to construct a home on the abutting piece. and live
So
in-
are both 144 and 39 are currently vacant, correct?
No,
They're not.
144.
144 has a
144
home
has
on
a
it.
house.
resident.
Okay.
Mom and dad live on 144. Son and his wife Amber are going to be constructing a home on 39.
And who, excuse me, Mr. Who owns parcel number 40?
Six, I didn't hear the,
Who owns parcel number 40, which is directly
Leroy
below?
Blackbeard.
Yeah, Leroy and Blackmer.
Oh, okay.
yeah,
And that's, I guess, where my questions begin, because it appeared from the map of where the cart path goes, that to reach Woonsocket Hill Road, you have to cross lot 40.
Can I approach with, it's the same
Oh,
plan that you-
absolutely.
Yep, go ahead, please.
Please. Okay.
They don't give us enough room up here.
Okay, the piece of property that we're talking about is this piece here,
Right.
okay?
Yep.
The cart path comes down, and here it says, right, provide access to the cart path, because this is how this piece was going to have access out to the roadway. Brentwood Drive, in my professional opinion, runs up one side, keeps on going, and does the cul-de-sac.
Yep.
Comes back and then cuts across, because this particular piece of property has a stone wall that runs right along like that. And that this piece used to be part of the big farm, I'm talking about 1862.
Maurice. The Maury farm.
Right.
Yeah, but
Yes, yes.
I think, well, you can probably go back, yeah, unless you have a specific.
Oh, yeah, so I have a specific question. So is this line
No,
the southerly line of 39?
right here. It's kind of hard to read. This is the plan that's recorded.
Okay.
So this area here, I blew this up to this. As you can see, the same lettering, proposed access to the roadway, and that this lot here, which
Right.
is lot 39, has the ability to gain access to Brentwood Drive via this contact. And they so stated here,
Right.
because this was part of the agreement from 1862.
Okay, but what does this
This
line represent here, then? That's what I'm trying to understand. I guess what I'm getting at a point, does the cart path at any point go onto a person's parcel other than the person who granted the easement?
Well, but I think, that's why, I think if you can, I think we need to step back and make sure we understand our role. And that is, I can wait for you to go back, but we're not the land court and we're not lawyers as it relates to land. So The only thing, and what I see that's missing, is a clearly defined easement on a piece of paper stamped by you as the surveyor of record that grants frontage, or not frontage, but grants easement to lot number 39.
Well, I gave you, the current deed description makes reference to to easements.
No, but we don't have, other than on your boundary survey, what I would hope other board members feel the same. I think in order for us to grant any kind of relief, we need to see an executed document that proves that lot number 39 has a right-of-way to Brentwood Drive, and this is a little bit cryptic. I can't determine in my mind that this boundary survey, which is our P8, clearly shows an executed easement between the parties of the other properties, granting the owners of lot 39, access for a driveway, I assume, to Brentwood?
Well, in 1862, they knew, the two abutting property owners knew it was going to be an issue, so they granted to each other the ability to utilize that cart path to gain access to the public roadway, which is, and again, was not Brentwood Drive, it was Woonsocket Hill Road.
And that's in the P4
And-
document? That's stated in this P4 document, that number?
That's
Right.
correct. And then when they
Right.
created the subdivision in 1966, they realized that there was an easement there.
Mhm.
So that's why they made special notation on the plan that lot 39 would have access via that cart path.
Yeah, but where is that, in today's world, in today's law, if you went to the Superior Court, how do you prove to the Superior Court that lot 39 has a right-of-way to Brentwood Drive? Since they
Because
have
if
no
you,
frontage.
that's
So
why,
What's that?
Wouldn't it be on P3?
Well, I don't, that's why I'm asking, he's the professional, I need
Oh, I'm
you to
sorry.
tell us. We can't, I'll defer to council as well, but we know we have a nonconformity. And the machinations of why we have a nonconformity, as interesting as they may be, aren't relevant to us as it relates to making a decision. We have a nonconforming property that is landlocked and has no frontage. It's a very creative solution, and it's a wonderful solution, or it may have pre-existed the solution. But I think we need an actual legal document that shows that, because as Chris was saying, this historic cart path crosses over into another property.
Don't I show that on my plan?
You do, but I don't see that it's executed as an easement on the plan. I mean, we have a easement document, right? And I think it would be much easier for us to deal with this is if you took the information that's recorded by that easement and put it on a plan, so the plan could then be voted upon, because the argument of the nonconformity is somewhat moot. You know, for whatever reason, the town allowed that 39 to be landlocked. And this is a nice solution to give access to that land, but for Steve, for council, can you just give a perspective? My opinion, other board members can speak freely, but I would want a formal document that is picture perfect clear to board members that says this is the easement, this is how the owners will get to Brentwood Drive.
Yeah, so first and foremost, not thinking that this application was gonna be heard tonight, frankly. I didn't read these documents with the page, just in all candor.
I understand,
But the zoning official and I are going through this right now, trying to find the easement. You understand what the chairman's asking for. He's asking
Absolutely.
for the written easement that's recorded on the deed or is made reference to by the deed. And we're going back here and there's a deed from 1860, what was the date on it?
1862?
1862, and it's on, it says page 34 of 359, and in your documents, I don't know what you've noted it as, but it's the third page in to a particular packet. I don't know how to reference it other than that. And it says in the second paragraph, it is therefore covenanted, granted, and agreed to between the parties. And what I'm trying to do is see if there's easement language here. it says to me what looks like it may be the word easement. Of course, this is written in handwriting, and it's fairly well written, but I'm not gonna profess that I can exactly interpret it. I was going backwards from the current deeds. I see the easement between Mr. Carey and the Lizottes, but we're trying to go back to see if there's a pre-existing easement.
Well, again, don't forget that 1862 was before Brentwood was there. Brentwood Drive was there. In 1966, when they prepared the subdivision, and eventually that subdivision was recorded in 1967, they made provisions on that plan to continue the access from Brentwood Drive now, because it was being accepted as a public road, not Woonsocket Hill Road, into the property, which is labeled as the easement on the old plan. the one that-
It would follow that that's the case by looking at the way this plat map is laid out, the location of the stone wall, all of that's a fair inference. Do you have any reference to any easement recorded on the deed of Mr. Carey that was then conveyed to the Lizottes, which specifically names the easement for access?
Yes, it does.
Okay, where's that document? Can you help us? That's what the board's
Yeah.
looking for. We wanna help you, but we need
No,
to
I
see
understand.
that. You follow me? So,
Mr. Archibald, wouldn't it even be, I would even be happy if they had, it was, the easement was certified in a title insurance policy when they purchased the property.
yeah, I mean, that would be the most recent form of the easement.
Right.
Just some reference that the easements. Will you go up and please point out to Norbert, who's presenting the plan where it is? Help us to help you. If you give it to Norbert, then we can show it to the chairman and we may clear this up.
Before you speak, if you're gonna speak, just
Yeah.
raise your right hand and identify yourself, please,
Andrew Lizotte,
and give your address.
120 Andrew Street, Woonsocket, Rhode Island.
Thank you.
All right, if you go back, I'm not sure which one you labeled it as, P4, P5, but it's the easement agreement with the town of North Smithfield. It was town clerk Joanne Buddy.
Beauty?
Yeah, Beauty, sorry. It was,
Does it list the book and page?
no, this is just the,
Oh, okay,
this is the,
all right,
I printed out for them.
all right.
It's dated, it was received and recorded on March 4th of '21.
And what is this you're speaking of?
This is the easement that was granted from my parents to Richard Carrier, who I purchased the land from.
Well, no, I understand. We have a lot of documents here.
No, I understand that. I
But
believe
what
he has
we
that page
need,
right there.
what we need, I want to see a drawing because we're dealing with a nonconformity, a landlocked piece of property. So we need to see something similar to the boundary survey that clearly defines and what is legal, and the surveyor is going to stamp it, what the easement is, where it is, so that we can then say,
No, but I was just saying there is a document with a granted easement from my
I understand that.
parents.
Yeah, I understand that. That's
To the
what you're
product.
saying is
That's that one,
P3,
yes.
but we're not here to read 300 pages. I'm exaggerating a bit, but I think you can appreciate the fact that it's not our job, it's not our responsibility to have to try to interpret all of this information and then build a case. It's your responsibility to come to us and show us the case. So you're 2/3 of the way there. What we need is a stamped drawing by the surveyor showing that he is showing us and proving to us that there is a legally recorded easement that grants you access over multiple or one property to your property. And I don't see that on what we're calling P8, so I think you should go back. And again, the verbiage is wonderful, but he can take that verbiage, since it's a legal document, and generate a drawing. We need the drawing.
So you just need a drawing showing where the easement goes to.
Yeah, because I think the crux of this matter, for all of you, which I think you can appreciate, is you've got your piece of property here. The road's over there. It's a no-brainer to say, yeah, of course, somebody made a big mistake when they did this layover, because they never should have not given you frontage. Okay, this is a creative solution, but our only involvement is to be shown that, okay, we can solve this problem because there's a legally executed easement that allows you to get to your property. And then we can try to make it all right. So I think you can appreciate that. And for us, if we have that document and it's stamped by the professional of record, then we can look at it. And the rest of it is fairly straightforward because it's a nonconformity that you did not create.
Correct.
It should never have been allowed to occur, and that predates anything you did. So that's what we need. And again, in fairness to us, I was operating under the premise that I only had to be half alert as far as analyzing all of this because it was going to be continued. But one of the first things I had said to the zoning official was that what we now call P8, the boundary survey, was inadequate. Even if we were prepared, in my opinion, as the chair, I was going to strongly suggest that we continue it until we get this formal document. So I think you're close. I think members understand clearly
Right.
what the issue
And
is.
to my point, shouldn't we also ascertain whether or not that easement does not cross onto another person's property? Because you may have an easement from the person that you purchased the property from, but he can only give you what he has if that cart continues on another person's piece
No,
of
the
property.
easement I received just from my parents from my parents' property to my property line, that's it.
Yeah, if you look on sheet of P8,
I know.
I thought it was, well, whatever the case,
But then we need the easement for.
yeah, but we don't, the legalese is not ours to debate. You give us a document that you swear and testify is a bona fide legal easement, and then we rule accordingly. If it crosses 4 properties, it's irrelevant. If it only crosses 1, it's not our job to know whether you notify 2 or 3 abutters. It's your job, as you know, as the professional, to certify that this is a legal document, and then we react accordingly.
I have a question, just for clarification, so I understand. Is it your position that the easement from the property you just acquired, 39, thanks, Carl, from the property you acquired, 39, is going to go and solely goes across 144, your parents' lot? It doesn't go on to lot 40 at all, even though there's an
Well,
existing
that's
cart path?
that's the historic cart path that we want to use. My parents gave us an easement that's just from 44 to 39, also, if there is complications.
That's what I thought. So that easement recorded in 2021
It's
is,
from 144 to 39 only.
and it doesn't touch 40 at all,
It does not
right?
touch 40.
See, that's where just, you understand a little bit of the confusion.
Yes, I do.
You didn't create it, it's just you've got this historic cart path going across 40. You've got 3 lots here, 39, 144, and 40, and the
Correct.
historic cart path cuts across 40, and there's a stone wall there, and that stone wall goes all the way back to the 1800s. We looked at a map that's all the way back to their plat map, so that's where the confusion comes from. The board's just trying to wrap their minds around what the relief you're asking for. Clearly, if there's a valid easement that's been conveyed, and that's your position, right? Is that there's a valid easement conveyed from 39 across 144 to the road, right? And that's what you're relying on this evening. Okay. And I mean, I can't discern where the meets and bounds are tonight, but if that's valid and that's accurate, then that's certainly a basis for the board to consider the grant of relief. They're just trying to get their minds wrapped around it. You
Yeah, but I
understand?
think we need to see the actual drawing.
The chairman's asking for you to put where that easement is physically on the map.
I mean, I think it's the only way to do it correctly, because otherwise we have no other
I'd ask
legal.
for a continuance,
Yep.
and so
Yeah.
that in turn I can
Yep.
prepare the documents,
Yeah,
prepare
perfect.
the plan, make the cross-references so that it can be graphically and accurately shown as to the access.
And honestly, that'll clear it all up, because we were all confused for obvious reasons. You didn't create it, but that's the confusion. Now, I think everybody understands, right? Everybody understands what we're trying to
Yep, Mr.
have.
Martin.
All right.
So Chris?
Thank you.
You were concerned with the property to the south, not the properties to the north, right?
Yes.
Yeah, okay.
Yeah.
So it's-
And historically, and that's what we just clarified, is that if we can keep it between 144, both, your parents and yourself, that would make, and so we're on the right page, we're all in agreement, we can go for continuance. The one question I had for clarification, planning board wasn't, is there any reason for planning, but this is just dimensional relief, Larry?
All it was a dimension.
Yeah, there's no reason for planning board to be
Pre-existing
involved.
lot,
Yeah,
correct.
exactly. Okay, so this is straightforward. Do we want to go to a continuing, the 24th is busy, or is it?
Put it, move it to the 24th,
Okay,
because I believe we're not gonna see the other one coming in,
okay,
so we'll just have that one case,
okay.
so they can come in on the 24th if Norbert can get prepared for it.
I can, I will.
Robert, that's okay for you?
Yes, sir.
All right,
I
so
got
you got it?
So I'll make a motion to move the application ZBR-23-01 to a date certain of January 24th, 23.
Second? Second?
I second.
All those in favor?
Aye.
Any opposed? Okay, thank you, gentlemen. I think we'll be on the right path. If you could, get that to the zoning official in time so that we can see it prior to the 24th, okay?
Yes, sir.
Thank you. Give us a minute for paperwork cleanup here.
If you go to the podium first, and then once they do all your general stuff, then you can just ask to pass anything you want out to them, or bring it up to them so they have it. Usually they get it to me ahead of time, so I can.
Okay, folks, we're ready. So, item B, under new business, is the application ZBR 2302 for dimensional variance by Manuel Garza, 109 Congress Street, Woonsocket, Rhode Island. Property is AP 06, Lot 91, with frontage located on Norwood Street. Requires 100 feet of frontage. The property has less than required by 5.5.1. And they're asking for a dimensional, and it's in an RU district. Before you start your presentation, let me just enter into evidence of what we have here.
Which one are we on? Two.
So P1 is the standard Town of North Smithfield application. Again, this is ZBR 23-02 for today's meeting date, and that 17-page standard document.
What date did you continue that to?
P2 is the abutters list. P3, I called the warranty deed, which was noted to be recorded at the clerk's office on 3/24/22. And that's for property address 0 Hillview Avenue. P4 is a drawing. It's a survey prepared by Marsh and Long. It's stamped by Stephen Long. His survey registration number is 1930. His signature is dated 11/8/22. The drawing is 11/8/22, and this is the, it's not titled necessarily, but it's the plot plan. And that's P4. P5 is the 200-foot radius for 91 and 73. That has no date on it, it's just a single page. So that's what we have. Your counsel for the applicant?
I am John Longo, attorney for the applicant. I have another handout that I brought it up for everyone for, if you wanted to mark it now.
Or what is that?
It's what I'm gonna refer to, it's reduced versions of the exhibits I'm gonna be referring to in the presentation.
Okay, please.
Is that a blow-up of the GIS map?
Yes.
So that's
well.
I have to admit, I still buy, trucks still buy there this afternoon, I couldn't even find it.
Yeah. It's indistinct right now. So I'm John Long, I'm the attorney for the applicant, Manuela Garza. She'll be testifying shortly. I wanted to explain why we're here. We're here because we're in an RU zone. Ms. Garza bought lot number 91. After she bought it, it was a survey revealed that this property line between lot 91 and 73 was right up against the house that exists on lot number 73. Lot number 91, her lot, is vacant. She bought it to build a single-family house. She saw it was over 20,000 square feet. Determined it was a, otherwise buildable lot, but then when she got the survey, it revealed that the property line goes right up to the house at 73. And this is that's Exhibit A, which is the GIS from the town. Exhibit B, which I've given you, is an aerial showing it. And if you see this blue dot, that's the one constant on all of the exhibits I have tonight. The blue dot shows where the lot is, lot 91, it's the backyard of lot 73. So she had no reason to believe that the lot would go against the backyard. It seemed like it was plenty big enough. So rather than making the other people tear down their house, she's trying to work with the owner of lot number 73, so he doesn't have to tear down his house. So what we're seeking to do is move the lot line. And we're going to shrink her lot slightly. My client's gonna shrink her lot slightly. It's still gonna have 20,000 square feet, which is what you need in an R1. But because we're moving the lot line, it triggered planning board review and subdivision approval. And we went to them for master plan approval, and they said they've sent us here because to move the lot line, we're in effect creating a new lot, and we're missing 13 and a half feet of frontage. If you look at Exhibit C that I handed you, you can see by the blue star, there's a notation that where the existing pavement ends, EP. And it says it ends 85.5 feet from the property line. And in this RU zone, we're required to have 100 feet of frontage. And as you can see on this map, the reason why the pavement ends is because the rest of this street is unimproved. Norwood Road continues behind this whole lot, but it's unimproved. It's only improved up to that blue dot.
Counsel, in your discussions, well, two questions for you. One is, we have nothing from the planning board. We have no letter of recommendation, so we're gonna need that. That was not submitted, and your application even indicates that you are to appear before them, so we really need, was a letter of recommendation issued?
I have the meeting minutes where the approved meeting, we didn't get a letter from them. We've got the meeting minutes where the motion was, motion by one member, seconded by another, to recommend to the zoning board of review a variance for frontage on the rear lot, plat 6, lot 91. So I have that.
But they never generated a memorandum from that motion?
No.
Well, you read the motion, but what was the vote?
Oh, it was unanimous.
Okay.
It was
So we're gonna
unanimous.
need that to be provided to the zoning official. I mean, if we hear that you've testified and you have the document from the minutes that the motion was taken and unanimously approved, then in lieu of a letter of recommendation, it's the same thing, but,
I didn't get anything.
yeah. So we need to at least, no matter what happens, we need to get a copy of the minutes, and/or you can approach the planner and ask him to generate the memorandum to put in the file. Can you, but the other question I have is, did the planning board give you any idea as to the town's attitude towards the continuation of Norwood Road?
There was no indication that they were gonna be building it, no,
Okay.
no.
Okay, and so this, and the other kind of shortfall of your Exhibit C, which is part of our, which is what we're calling our P4, is that I don't quite understand why Marsh and Long couldn't have told us exactly how much relief you were asking for.
So the,
I can understand now, you said you have 85.5, so you need the differential.
yes, and that's, on the exhibit that I submitted tonight, Marsh and Long, noted on what I submitted tonight, where the existing pavement ends. So if you look at that little colorful package I gave you, number C.
Yep.
That's the updated one where they noted where the existing EP ends. It's right by that blue star.
But you note that, but for the record, nowhere in your application does it say, we are asking for 25, 35, 50 feet of relief. We all understand what you're trying to do, but you never gave us the base level of, we need 27 feet, you know, for example.
I apologize for that. That was my error, not the applicant's. Well, my error, and I represent the applicant. So yeah, so it's 13.5 feet that we need relief from. And I'd like to submit then as an exhibit the meeting minutes from the October 13th Planning Board meeting, just so for the record. as,
Yeah, we
P6.
might as well, yep, okay. What was the last P, Tiffany, please?
P5, so this would be
P5, so this is
P6.
P6, so thank you, sir.
We didn't put this one in there.
Oh, that's right, we have to put them both in, so we'll call the council's Exhibit A, B, and C will be the 6th, since that was provided today, and council's copy of the planning board North Smithfield meeting minutes from October 13th of 2022, we'll call P7, and all can peruse this if they want to read the motion itself, but we're trusting that what the attorney counsel read was correct. So you're basically, you granted them an easement, or you would propose to grant them an easement in the top corner or the top, along the back wall?
Yes.
Common law with the
What's-
73?
What's still gonna be on my client's land is some of a patio. So she's indicated to the other homeowner, I'm not gonna make you tear up your patio, I'll let you keep your patio, I'll give you an easement to maintain your patio.
So that's Exhibit B. When you look at Exhibit B, that, the lean-to off of that building is kind of, and then there's a deck that comes off of
No,
that?
the patio is just pavers.
Okay,
So the easement there is just pavers, it's not any structure.
okay.
The property line is right up against the structure, but then the, I'm calling them pavers. It's,
And then I guess a legal question for both our council and you. What happens if the town, at some point in the future, disbands the continuation of Norwood Road? Does that land then become half and half to the abutters? Is that how that works?
There's a whole process for abandonment the town would have to go through with notice, and it's a little involved. It would take me 5 minutes to lay it out to you, so
Okay.
it's involved. We could deal with that.
But there's no jeopardy.
No,
By granting this relief,
No.
it has no impact on what the future may bring. Because if the road were paved, it becomes moot.
it has no adverse impact
Okay.
on the applicant after you grant the
Okay.
relief. It does have an impact on how the town would weigh out what they were gonna do, but that's not any reason to hold any prejudice
And if the
against
road were
applicant.
paved next year, the relief becomes moot because they have more than enough frontage.
Yes.
So, okay.
That's exactly
Yeah,
how I see it,
okay.
right?
All right, I just wanted to make sure that we understood that there was no issue. So,
And we can't shrink the lot because, you know, we need 20,000, we're keeping 20,000, so we couldn't, if they improved the lot, we couldn't somehow shrink the lot because we still need the 20,000 square feet.
so just to clarify for our own purposes, the easement triggered, but no, you would have to have come here anyway.
Yes.
Because you didn't have the frontage.
The frontage is
Whether
the issue.
you gave the easement or not isn't really relevant. It's informational for us, but it's not the reason to come to us. The only reason is the 13 feet.
It's actually the other own is non-conforming.
Well, yeah, because it's, you're coming to us because you need the 13.5.
Actually, can
Mr.
the
Chairman?
zoning official clarify that?
So just so you know, both of the lots are pre-existing. The front lot was much less conforming than it is now by moving the line, because the house used to be basically right on or just over the actual property line. What they did is they moved the lot line down further onto that lot to give more distance between the house and the property line. So this way here, it made the front lot more conforming and kept the rear lot, or the lot in question, conforming by doing that. So it didn't really adjust that. The only thing that was the question was the actual patio from the property.
Yeah, recall, you and I had that conversation, which is a good thing, because you took, you reduced the nonconformity of the lot 73.
Yes.
And also then ended up being neighborly and providing for relief, so,
Yes.
okay.
So really, all they're looking for this evening would be just that frontage relief of that 13 point whatever feet.
Anything else?
I would just like to swear in my witness and ask her just a couple of questions.
Sure. If you could stand, please, and put your right hand up and give your name to the secretary, please.
Manuela Garza.
Ms. Garza, do you swear the testimony you will give this board will be the truth, the whole truth, and nothing but the truth to help
I
you
do.
God? Okay, and you own what we've referred to as lot number 6, excuse me, lot number 9, correct?
Yes.
And you bought this lot, after you bought the lot, that's when you discovered the survey discrepancy with the other property and its house?
Yes.
So you didn't do anything to create this problem?
No.
Do you think allowing your lot to be buildable will alter the characteristics of the general area or impair the intent of the zoning ordinance or the comprehensive plan?
No.
And are you requesting the least amount necessary, just the 13.5 feet, the least amount necessary to conform with the 100 feet of frontage requirement?
I am.
And if you didn't get this relief, you wouldn't be able to develop, and you're only seeking this relief to develop it as a single-family house, right?
Correct.
And without this relief, you wouldn't be able to develop it as a single-family house,
Sure.
correct? Okay, I don't have any other questions.
I think you referred to it as Lot 9. It's Lot 91,
It's,
right?
yeah. Lot 91, I'm sorry. I wrote in my notes 9. My 1 looks like a comma. But yes, Lot 91. Ms. Garza, you bought Lot 91?
Yes.
Okay, thank you. And I do believe there's people here to speak on this, so.
Yeah, that's fine. Okay, if both of you, if you're finished. So we'll open the public participation. If there's anyone from the public that would like to speak on this application, please indicate so. Come forward, sir, if you will. Go to the podium and then just raise your right hand and identify yourself.
My name is David Del Torrio. I live on 19 Oakdale Road.
Did you hear that? I'm sorry, I didn't know.
I'm sorry, David Del Torrio. I live on 19 Oakdale Road. I'm a butter to the proposed property. I just have a few comments. I'm not sure what information the board has. So I'd like to, can I hand you some information to support some of my comments and questions? There's some pictures. There's a plan that was submitted with the subdivision application, and plans and elevations of the proposed house. So that'll help the discussion about, does it fit into the neighborhood?
Oh, and this was prepared by whom or what?
Much by myself.
Oh, yourself, oh, okay, yeah, sure.
It'll just help when I reference some of the,
That's fine. You have enough for all of us?
I only made 3 copies, sorry.
Well, you go back because you're being recorded, so we just need to make sure that anyone who's watching can clearly
Okay.
hear all of this.
So I'm providing the board copies of, Exhibit 1 is just 9 pictures. Exhibit A will be the plan of land submitted with the subdivision application.
Well, one moment, let's just make sure so this isn't a P, because this came from the floor, so this would be, yeah, because it's, no, public we don't want to use P for public, so we can say A1 for accessory or alternate, so this will be A1 from public. And let me just, hold on, for the record, this is how many pages, sir?
9.
9 pages of pictures without any dates or any addresses. It's just 9 pages of pictures submitted by an abutter, so.
Apologies, I wasn't sure of the process.
Yeah, that's okay. So why don't you then walk us through whatever it is, the point that you wanted to make?
I just had 2 other items. And item A is another plan.
Yep.
It just provides more detail, site details. It was submitted with the subdivision application.
When you reference subdivision application, what are you referencing?
To the planning board.
A subdivision application, or?
Yeah, by the applicant, to subdivide the 2 properties.
Oh, okay, I'm sorry. Yep, okay, you have something else?
And then Exhibit B was just plans and elevations of the proposed house.
Yep,
on
which
this
we
property.
have already, I believe.
Okay, I wasn't sure if you had
Yep,
them.
yep.
Do you have these?
I think we do we not? Oh, no, we don't, I'm sorry. All we have is a drawing showing the footprint, a plot plan, so.
I just think it's important as to, the discussions about does it fit into the characteristic of the neighborhood.
I should caution you that you're free to bring up anything you'd like, but as to the relevance of our responsibility here,
Understood.
we have no jurisdiction as to the aesthetic value of, the architectural value of,
Understood?
anything in that regard. So you just need to understand that our job is to either grant the relief requested for the frontage or not. So mindful of that, you can continue.
Okay, I do understand. I think it's helpful when we discuss, I think it's relevant to the board. One of the requirements is, that you think of when you're voting on the request is, does it fit into the characteristic of the neighborhood? And I'd contend the house that's proposed doesn't. And I can reference some of the pictures that I submitted under A1 as we're talking about that. And the plan, the second exhibit I'd like to submit just shows more detail of the rear lot line, and it's relevant, I think, because, I'd ask the board to think of as additional variances required based on some of my comments and questions. I don't know, that's.
You
why
have
I'm here.
another set of drawings?
Just what was submitted with the,
So you're going to reference one of the
yes, it's similar to
documents.
this plan, but
Okay.
it has more information. It shows where the driveway is, it shows where there's concrete curb, it shows where there's walkways.
Is that, who prepared this?
It was prepared by the applicant's Marsh and Long survey. And again, it was the plan that was submitted with the planning board subdivision application. It's just different than the plan.
Okay, why don't you proceed first with your A1 submittal, or submission?
Well, I might jump around, so it might be easier to.
Well, whatever, but we just need to move forward. So you took
Trying
a
to.
series of pictures. Can you walk us through the pictures?
Sure. So the first picture is just the frontage,
Yep.
just to give a reference of where we are. Same shows, the second picture shows the corner of the Oakwood and Norwood. Oakdale and Norwood, I'm sorry. The third picture is just kind of, this is the neighborhood type, within a 400-foot radius of the property. These are the types of houses, and this is the type of neighborhood that this house
Which
is.
drawing was that?
That's
Three.
picture number 3?
Yep.
I have a question on that drawing. The house is on this road. This is Loppy Road is what?
Nope, that's Westwood.
That's Westwood.
a lot of these houses were there for a long time. They're in 1950s, 1960s, so
Correct.
how can you ask somebody to build a house that looks like something from the 60s or the 50s?
I just say similar in style, similar in size. Again, I didn't write the zoning ordinance, I'm just, it's supposed to be,
This is not a historical.
Okay, well,
you say it's not admissible, but
Yeah, why don't
I
you-
might just like to continue.
why don't you continue?
All right.
Why don't you continue?
4, again, is a picture of, these structures are part of being on the applicant's property. And it's just that, same 4, 5, and 6 show that there's parking, there's pavement for the parking lot. That's the so-called patio. Now, I know it was just described as pavers. It's not pavers, it's a substantial structure. It has utilities in it. And I just contend if it has utilities in it, it's, I believe under the subdivision design standards, it should be deducted as non-developable as part of that parcel. It's section 5.1 of the land development. That should be considered unsuitable for development shall be deducted from acreage. If it's privately held easement, that includes utilities.
Yeah, but
So
again,
if that was the case,
but
you would
you-
be asked for a variance of size.
No, but you need to stay on track, if you will, sir. Anything to do with subdivision is not relevant to this board.
Okay,
If those are questions you had or have,
right.
then the place to bring that up was at the planning board, because that's their domain. We're happy to accept what you've submitted, because
Okay.
it's your,
I appreciate it.
right to submit it. We don't, whether we are able to legally entertain it or not is our issue.
Okay.
But again, anything that has to do with, and I'm not saying that your claims are accurate or inaccurate, but they're relevant to the planning board, not to this body.
Understood. Can I ask what you submit to the planning board?
We
After you-
submit nothing, no.
You don't submit whatever you voted?
No, no, they go to the planning board first. The
Correct.
planning board has to approve it, and then they give us a letter of recommendation.
Yep.
And then we deliberate on our own without any involvement from any other body, so.
Just simply on the request being asked?
Yes, yes. Anything to do with land use and things of that nature is the
Okay.
planning board. And we have, our jurisdiction, as complex as it may appear, is fairly straightforward as it relates to variances
Okay.
and special use permits.
Understood. I guess I would like to, just as a correction, the pictures, pictures 4, 5, and 6.
Yep.
It's not simply, as it was explained, they're not pavers. And Mr. Chairman, I think you mentioned there'd be no adverse effect if the road was paved. It'd be an adverse impact to me, as right now, it's just a right-of-way, it's not constructed, so.
Well, no, you should clarify, what, my words were very clear, that if the town owns the property and the town decides to continue the road, then the town has the right to do that, and if they did, then the frontage on the property in question is moot, because it's compliant. So that was my only point.
Understood. I just heard it as, there'd be no adverse effect to anybody if it was paved.
Well, because the town owns it, by definition, they have the right to do
No,
it.
it's not a question of a right,
Yep.
and I'm not arguing. Under your jurisdiction, I'll go through your regulations, 931, that a hardship from which the applicant seeks relief is due to the unique characteristics of the land. I'm not sure there's anything unique to the property, is my contention. Under 931B, that the hardship is not the result of any prior action of the applicant and does not result primarily from the desire of the applicant to realize greater financial gain. I ask, what does that mean? What if they sell the property? if their intent is just to develop it and sell it. I know a development company purchased the front house, and they're in the process of trying to sell it. I think the whole process of the subdivision and it has got nothing to do with anything but financial gain. Under 931C, I think the granting of the requested variance will not alter the general characteristic of the surrounding area. Excuse me, that's where I reference the pictures. That the relief to be granted is the least relief. Again, I was trying to explain that there could be a possibility there's additional variances that, other than what has been presented today, based on some of the descriptions of the property and what's involved, and is it really a 20,000 square foot property or not? Under 931E, the granting of the variance requested will not confer any special privilege. I contend there is a privilege. Every property, Hillview, Norwood, we all paid a sewer betterment. This property is not going to be required to pay that sewer betterment. They'll have a connection fee. So to me, that's a privilege.
Well, I
They'll
think
be granted.
you should just be careful. That's more of a circumstance than a privilege. You can't fault yourself or anybody else who owns the parcel in question. That's a circumstance, it's not a privilege.
Not only that, while that is currently in our zoning ordinance, we were advised by the town solicitor recently that we're not permitted to consider that in a variance application.
No, that's something else.
It just had to do with that.
No, that was the other one. That's not that one. That one is correct. It's the other one. That's no beneficial use.
Oh, no, that.
Yeah. But again, continue if you could, just to
Sure.
try to wrap this up.
Well, it's my only opportunity.
I understand.
So I hope you don't have to rush me through everything.
Yep.
932, under B, granting a dimension variance. I think there was another alternative. The original purchaser of 54 Hillview, even though these are two different lots, they've always been one lot when the house was originally developed. So, you know, they could just buy 54. So, instead of build another house on a lot where you have significant impact from 54. And there's gonna be an easement required for a significant portion of the parcel, so. Anyway, just trying to take my opportunity where, the
Yep.
only opportunity we have, so, thank you.
And the one thing that we should note, just for your information, I mean, you know, you're entitled to do whatever if you can prove something legally that the applicant has misrepresented, you have every right to do that. The only thing we can rely on is what is given to us in sworn statements and stamped drawings by professionals.
Oh, understood.
And if we get a plot plan that says X, Y, and Z, if you will, we have to defer to the professional who stamped it as it being accurate. If you know it to be otherwise, you certainly have the right to see the zoning official at his office and indicate that something isn't correct. And then we would take action accordingly. Same thing with the planning board. If there are things that you thought were not proper, they're the ones that you should discuss it with the planner and let him explain what his opinion was, whether they agreed or disagreed with you, so.
Okay.
We'll accept everything that you've referenced, and again, as you know, we have to rule on what you just reviewed, so.
Oh, wait, thank you.
Any questions for the abutter, for the public? Thank you, sir. Is there anyone else from the public that wants to speak in this regard? Hearing none. Oh, we do? Go ahead. Again, just raise your hand and identify yourself for the secretary.
I'm Irene
please.
Shuchuk at 38 Norwood.
Okay, thank you.
Today's meeting with the zoning board, is that strictly to do with whether there should be 100 feet in front of it? Or is there
Correct.
more to this meeting?
No, this is simply to grant them or deny them 13 and a half feet of frontage.
Okay. And the second question is, what was resolved about the back of the property, the property that is along the patio.
In
Was
what
there-
regard, when you say resolved?
Well, last meeting, in regards to this, there was trying to move the property line
That's the planning board meeting?
at the zoning board.
No, it's had to be planning board. The applicant has never appeared before this board prior to tonight, so.
Yes?
No, they have not. Yeah, that was planning
Oh,
board.
planning board.
Okay.
Oh, okay.
I might be able to shed light on what she's referring to.
I just wanted to know what was
Yeah, go ahead,
resolved.
sure, if you can help.
So at the planning board, there was a discussion of, the planning board suggested, rather than an easement, why don't you move the lot line even further, so there would be no need for an easement? But our position was, well, we'll do what you want, but then we're gonna be creating an undersized lot. We're gonna be, the lot, my
Mhm.
client's lot would be less than 20,000.
Which,
So they went
yeah.
back and forth, and then they came down with, okay, do what you proposed, which was the easement, so the lot remained 20,000 square feet. So that's what that's what was done, yeah.
Okay, thank you. And we have those minutes for that note that the motion was approved? The planning board minutes?
Yeah, P7.
Yeah. Okay. Are there any questions as to that the planning board minutes, Kim? You see, just if you could, just double check the motion and confirm that it was approved unanimous. It doesn't have to be unanimous, but if that's what it was, that's what it was.
I put big marks in the margins by the rule. It went back, there were a couple of motions.
Yep.
I forgot to submit the article.
Oh, okay, yeah, go ahead. Yeah, I just have to mark it. Yeah, but this would be A2, 1 of 5, it looks like. These are.
I just have one question for Mr. Del Torrio.
Yeah, please come back.
I'm sorry. Is there somewhere on this plan that you can show me where your house is? On the bottom? You're right there. And you'd be able to see her house from your house? Without all those, you have a lot of woods in between.
It's the woods of the Norwood Road, the right-of-way.
And it keeps going on in the back where it's undeveloped?
It stops right after the next parcel. So it's a dead end paper street.
Okay, thank you.
Okay, well, A2 was a 5-page set of drawings. Soft plan, architectural design created by Boschman's Design, Woonsocket, dated June 1 of 2022. Again, this was submitted by a member of the public. Okay. Are there any other questions for the applicant and/or the public that spoke? Hearing none, can I have
Make a motion to close the public.
Second?
I second.
All those in favor? Aye.
I'll make a
Okay.
motion to close the applicant.
The same, second?
Second?
All those in favor?
Aye.
Okay, thank you. We'll go into deliberation, and for those in present, that we have to go through the variance approval standards, which is 9.3.
Mr. Chairman,
Go ahead.
before you do that, so I happened to be looking at the non-conforming lots of record section for the other applicant.
Yep.
And I came across the 421, which is a merger of multiple non-conforming lots of record. And I guess it's more of a question for the solicitor, if it applies to this or not. It says, "For lawful establishment lots with continuous frontage in a single ownership, which are located in the REA 120, RA 65, RS 40, or RU 20 zones, if all or part of the lots do not meet the requirements established for lot width, frontage or area, that the lots shall be deemed to be merged and shall be considered under this ordinance as an individual lot, and no portion of said lot shall be used or sold in a manner which diminishes compliance with the lot width, frontage, area requirement established by this ordinance, nor shall any division of any parcel be made which creates a lot with frontage or area below requirements stated in this ordinance." So I read that, and, you know, both these lots were non-conforming. 73 was non-conforming because of lottage, and 91 is non-conforming because of the frontage. These were both owned by the same person for many, many, many years, sold many, many times over as a pair. My question is, why didn't 421 kick in here and merge those two non-conforming lots, based upon what I just read? That make sense?
I follow you.
Okay.
I think the question of merger was appropriately to be considered at the planning board, if it were to be considered at all. I think it's beyond the scope of what's before you today, and I don't think you should go down that rabbit hole.
Okay.
Yeah, it's, that clearly, they saw everything. They, if anything, the way it was explained by the zoning official, they reduced the nonconformity of one of the two, so it's really not ours to debate, and if it passed their approval and muster, then
So
in
the
that
question
regard, it
was,
is what it is.
if that was to kick in, it would've kicked in at planning. When this came in front of them,
It should
the
have.
planning should've kicked that in and said that, assuming that this was right.
If the doctrine of merger did apply, it would have been addressed at the planning board. It's not within the scope of your authority
Yep.
here, and I don't think you should pursue it, consider it. It's a very good question.
Okay.
Not undermining the questions, just to go down that now would be to go down a rabbit hole where we don't belong, so.
Okay.
Thank you.
Thank you.
Okay, so 9.3.1, again, A, that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not to the general characteristics of the surrounding area, and is not due to a physical or economic disability. Again, looking at what we have in front of us, it's quite clear that the hardship is unique to this property, because if the street continued as it is defined on the public way, the frontage would not be a problem. The road was never continued, so therefore there isn't enough frontage. I think it is unique in that regard, because clearly when the road was laid out, it was intended to be a road. Otherwise, it would have been a separate piece of parcel and would have owned it, then the whole thing would have changed. So it does appear that the hardship is unique to that circumstance right there, that the public right-of-way exists, the road was never completed, therefore there's not enough frontage. Any additional comments in that regard?
I would just also just add, Mr. Chairman, if you look at P6, that if the road had continued, you will also see that to the, I'm just gonna call it to the left
Yep.
of the picture.
Yep.
I don't have a directional bearing. There actually is another lot.
Yeah, there is, yep, there is.
Well, it's
Yeah, but that's
70
beyond,
foot frontage,
yeah, but
so
that's
that'd be-
beyond the 100-foot frontage.
Yeah.
So either way, if
Are you
the,
talking about 75?
yeah, piece, that green.
They'd have the same, he's talking 75.
Yeah,
Which would
75.
be 30%.
Correct, correct. And the road would have ended at the green
P6.
there in P6, even whenever, even if it is built.
So I think I know the answer to this question, I just want to make sure. That is a paper road that's there, so they can't include any of that paper road for their frontage, and that's what we're
That's
discussing.
the issue,
is- that's right,
correct,
that's right.
correct. Because it's undeveloped.
Right. And regardless whether the town developed it or didn't develop it, that's a moot point because it's all paper road, right?
Yeah.
Yep.
Yep. And if they did, then the relief granted, if it is granted, would be of no consequence.
Mr. Chairman, do I have this right? Yeah, 13 feet
shy?
Yeah, 13.6, yeah, 13 foot 6 inches short. They have, we're told that that blue star is
Yeah.
at 85 foot 6 inches.
So that's what we'd be granting, we'd be granting a variance
Hold
on
on,
that
one
13
at a
feet,
time.
right?
What's that?
We'd be
13.
granting a variance.
Yeah,
on
so
that
the
13.
relief request is the differential between 100 and 85.6.
Right, which is
0.5.
14.5 feet.
Correct, yeah, I'm sorry. Yeah, that's right. Well, I think whatever we do in the motion, if the relief is granted, we should insist that, require that this drawing be updated to clearly define on the plan
The
what the
Where the road
actual
ends.
relief
What-
is.
Yeah,
what
and where the
exhibit
road
is
ends.
that?
What's that?
What exhibit is it to, like?
This is P4.
Okay.
Yeah. So P4 should be updated if relief is granted to clearly define the relief.
The relief and the actual blacktop, because it's
Correct,
tough to
yeah.
tell on
Yeah,
that drawing
exactly,
where
yeah.
the blacktop ends and
Yep.
begins.
Where we will assume for the purposes of the decision that
Did I
it's
throw approximately?
14,
in there,
yeah,
subject
yeah,
to?
14.5 feet, subject to confirmation by the surveyor. So item 9.3.1B, the hardship is not the result of any prior action of the applicant, does not result primarily from the desire of the applicant to realize greater financial gain. Clearly, there's no prior action by this applicant, they bought the property. Financial gain,
We struggle with that every time.
well, again, obviously, you can interpret financial gain 100 ways. In this instance, we're presented by a individual who wants to build a house. The financial gain obviously is inherent in the fact that they're building a house, but they bought a residential lot that entitles them to build a house. So I don't see financial gain as an issue here. And the prior action had obviously clearly nothing to do with the applicant. Item C, that the granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of this zoning ordinance or the comprehensive plan upon which the ordinance is based. Will not alter the general character. And again, the member of the public who was concerned in that regard, this is a residential district. The size of the dwelling is really not our domain. That's planning board. If coverage is an issue, that's planning board. It's not ours. If no variance is requested, anything they do has to be compliant with the building and zoning official. So it's a residential address and it has a residential proposed structure. That is clearly in keeping with the character. Whether the existing homes in the area are old or new isn't really relevant because it's a residential district, in my opinion.
Mr.
Or
Chairman?
impair the intent of the zoning. Go ahead.
Oh, you don't see?
And I had also noted that, I had indicated that as part of that, if Norwood was ever continued to this green property here on P6, the relief would be moot because it would not be needed. So go ahead.
Yeah, you're right, that it would be moot, but because they're looking for an ordinance, they have to go by these tenants, right? I actually kind of looked at that neighborhood to look at the square footage of the houses that are there now.
Yep.
The house that is proposed is almost 3 times the size of the average house that's in that neighborhood. So my interpretation, looking at C, is that it would alter the general characteristics of the surrounding area because of the sheer size of that house. Whether that's relevant or not.
Well,
To me, it's relevant.
it may be relevant, but
dimensions.
the bottom line is if it complies with the coverage ordinance, the coverage requirements for that address, it's not ours to say that the house is too big. I mean, and again, that's a bit of a nuance of, well, I think it's too big, you think it's not too big. But if it doesn't require variance for coverage of the lot, then by definition, you or I could do the same thing if that's the size of the house we wanted. It's a good point you make, but
And after a visual inspection of passing by the building, it does now represent kind of like a corner lot, and it's kind of offset, so you wouldn't actually really see the house while all the other houses are exposed.
Because of its location.
Right.
Okay. That's always a kind of an issue,
Right.
but again, within our purview. So item D, that the relief to be granted is the least relief necessary. And again, since 100 feet is required, then the differential between 85'6" and 100 would by definition be the least relief necessary. And again, that's assuming that the surveyor would confirm that dimension. Item E, that granting the variance requested will not confer on the applicant any special privilege that is denied by this ordinance to other land structures or buildings in the same district. Again, in this case, it's a property that's on a town road. The road is paper beyond a certain point. It doesn't exist, but legally it's there. So it's really not a special privilege, because that circumstance, the only other property that applies to is lot number 70. And for all we know, that may have a house on Hillview and not on Norwood. So you're really not granting a special privilege, because, you know, 140, lot 140, if that's the frontage on lot 140, you know, they would be in the same circumstance, conceivably.
The small houses are on small lots. He's got one of the bigger lots there. He's got
Yep.
160-foot frontage. Some of them only have 60.
yeah.
Yeah.
So you had nonconformities all over the place at some point.
Mhm.
9.3.2A, in granting a use variance, this is not applicable, it's
That's
not a use variance, I'm sorry. 9.3.2B, in granting a dimensional variance at the hardship that would be suffered by the owner of the subject property if the dimensional variance is not granted shall amount to more than a mere inconvenience. And shall mean that there's no other
No, no,
reason, yeah,
it-
that's the part we
that's the
struck,
part I
yeah.
would-
So it's just,
Think of the fact, though, you
more
know.
than a mere inconvenience.
The
The
fact.
fact that there may be a more beneficial, more profitable, or that a structure may be valuable after the relief is granted shall not be grounds for relief. In that regard, I think it's pretty straightforward that if the easement is not, if the variance is not granted, then the house cannot be built.
Yeah, I always struggle with that, with B for the greater financial gains, right? It said, you know, realize greater financial gain, but then down here, they're saying, you know, the fact is, you're more profitable, the structure may be valuable after relief is granted, should not be grounds for relief. You know, it's kinda.
Yeah, but you can't, again, you bought a piece of property that's residential zoned, and you want to build a house.
No, I know.
And there's not enough frontage because of the uniqueness of the way the town road stopped.
Yeah, I just
So-
think it's contradictory the way they do that with the greater financial
Well,
gain.
that's,
of B,
but
and-
the whole thing is subject to.
But like you said, greater financial gain can mean a
is-
lot of
yeah,
things.
it's a very ambiguous,
Yeah.
but it gives us leverage to go in multiple directions, so. And it is what the state law is, so that's what we do. Okay, any comments on that regard? Okay, hearing none, before we, just to clarify, Tiffany, we have 5 voting members, correct? And the first alternate will vote in place of Mr. Marston, right? Okay. All right, so,
Can I just-
go ahead.
I just want to add one thing. So January 1st, the rules changed.
Correct.
So it used to be you needed 4 for approval. Now we need 3 for approval.
Correct. But again, it works the same way. They never say 3, they say the
Majority.
majority. So, but by definition, it's 3. Whether you have 5 or you have 4, it's still 3. They just don't, they say majority.
Right.
So, either way, we're compliant, so. Okay, do we want to close discussion?
I'll make a motion to close the deliberations.
Okay,
I'll second that motion.
all those in favor?
Aye.
Okay, Chris or Gail, who's going to read the motion? And again, we're making the motion in the affirmative, that's just what we do.
Okay. I make a motion to approve application GBR 2302 by Manuel Garza, seeking a dimensional variance, specifically relief from section 5.5.1, minimal frontage requirements in an RU district. Said relief is approximately 14.5 feet. Said motion is subject to the applicant submitting a revised site plan currently submitted as Exhibit P4 to clearly define the dimension of the existing frontage and also delineating the precise relief requested.
And then also, if I could make a friendly amendment to add that the planning board memorandum be submitted to the zoning official.
What he said. Do we have a second?
Second?
I second.
We have a second. Do we need to read it again?
I'm good.
Are we good?
Yeah.
Roll call vote, please.
Mr. Najarian?
Yes.
Mr. Martin?
Yes.
Mr. DeZio?
Yes.
Mr. Mark Antonio? Mrs. Burlinghoff?
Yes.
Thank you very much. Good luck.
Thank you.
Give us one moment, please.
Do you have a big one here?
Okay, I think we can continue. The ZBR 2303, it's the application for a special use permit by Kevin and Linda Crowthers, 600 Greenville Road, North Smithfield, to construct a residential ground-mounted solar array on the land they own at 600 Greenville Road, AP 015, Lot 226, in an RA zone. 5.7 solar voltaic system and 5.74 requirements for solar accessory use. 5.75 ground-mounted solar. Special use permit in a RA district is required. Who's present on their behalf? Nobody? Oh, sir. If you could come forward, there's one complication, if you will, and that is, and you are, sir?
Kevin Crothers, 600 Greenville Road.
Okay, so you're Kevin, okay. The issue that we have here is you're going to need to continue this. We consulted, you can read the ordinance yourself, and it appeared that you did, but while 5.7.4 is accessory use, and you fall into that. However, 5.76 is submissions that are required of all solar. So part of that is that you need to prepare a site plan, and you need to go in front of the planning board for site plan review. That's 5.6.7, ground-mounted solar voltaic procedure and submission requirements. And again, a site plan is required, site plan review by the planning board, who then will upon review, if everything is in accordance with the ordinance, they will approve, and they will send us a letter indicating such. But short of that, you really need, if you did all of this on your own, then you really need to, with a fine-tooth comb, go over 5.7.6, because we gave this consideration. I went directly to council to get their opinion and make sure that we were all of the same mindset, and that is that even though you are a accessory use, 5.7.6 within the ordinance is quite clear that it is required of all applications, including accessory. So you need to go over that, and all of it says submission to us, and then site plan review is very clearly stated under B. And it also indicates that the zoning official and the town planner shall not have the authority to exempt the applicant from site plan review. So we can continue you to a date certain, but I don't think that's recommended because we don't know how long your site plan will take to prepare and when you can get on the planning board. So you may want to just withdraw your application, or we can just hold it in just hold it.
Well, if I withdraw my application, I have to pay another application fee, right?
No,
Yeah.
no, we would waive that. We're not gonna,
We
yeah.
can call it,
Yeah.
we'll adjourn it without
Yeah.
date.
Yeah, we're not gonna make you do it again. Yeah, that's not the point. We're not trying to be punitive. We're trying to abide by the law.
Is there a
I
legal,
understand.
is there a legal term to do that?
Yeah, you would table the matter, and you would ask the applicant to withdraw the application so that they can pick a date after they go to the planning board. You understand? We don't want you to pay for the advertising. Typically, it would be that we pick a date certain, but you may not be to the planning board if we pick the date certain for you. So that's what we're trying to sort through, so.
Okay.
You know, the cleanest way, I guess, would be to put on the record that there won't be any cost to you again. The problem's gonna be, it has to be advertised.
Yeah,
You
yeah.
gotta advertise it.
I mean, in fairness to us and to the town, we respond to what we're given. If the zoning official, you give it to him and he says, well, sir, there's 5 things missing here, go back. You know, there are many that say, well, no, that's not proper. He's supposed to receive it because the burden is on you. So you came to us, and what you came to us with is inadequate, insufficient. So we do have the right, which we're exercising, because this is to your benefit. If you forced us to rule otherwise, then we have to rule only one way, because we don't have what we need. So the burden is on you to do it right. We will try to minimize your expense, so to be fair.
Mr. Chairman, you know what we could do? We could pick a date certain out, some period of time.
Give them a
and then-
lot of time.
Yeah, and if the applicant's not before the planning board at that time, we can revisit it on the date we picked that was certain, and then just pick another.
You want to shoot for February?
Yeah, give them a little bit of time to get back before the planning board, maybe like later February. What do you think, Larry?
Yeah.
Well, planning's gonna probably take probably a month to get on there.
I would think so, yeah.
I mean, he still has to get a surveyor and whatnot, so I mean, I think you should probably do March. if
Why don't we
you-
do March?
What's our first March date?
I don't have a calendar in front of me.
Really?
That complies with notice and opportunity, all due process, and then it saves you the fees for filing, so you can come back.
Thank you.
You're welcome.
What you should do then in the interim is, I would strongly suggest that tomorrow morning, you go see the town planner. You explain everything that you're proposing to do. And also, you're gonna need a site plan, so you're gonna need to, if you hadn't already, I don't think I saw anything that was stamped by was it stamped by a surveyor? No.
This is the
Yeah.
same thing that was actually.
What'd you say, 14?
Yeah, but it wasn't a legal document. So you need to get in touch with a surveyor to generate a formal drawing, because we're gonna need to see the same thing, you know, where the property lines are, what your abutters can and cannot see. So you need to do two things right away. First, I would get the surveyor on board, explain what you're asking them to do, and then as soon as you have that person under contract, go see the town planner. And the zoning official will be happy if, between the planner and the zoning official, if you have trouble, you know, discerning everything that's in 5.7.6, you just check with them and they'll be happy to walk you through it. But I'm sure you can figure it out based on, you know, how thorough some of these submittals were.
Okay,
All right?
thank you.
And then, you know, there's always the chance that if you think you could make an earlier meeting, although we're announcing it as, once we continue it, we can't change the continuation. So we're just gonna have to go with the 14th. And if for some reason the 14th isn't gonna work, we could then date certain at that point, so.
Okay.
You have enough time, I think, to get it all done, so,
All right,
okay?
thank you.
Date certain part off.
Yeah, so we'll make a motion to continue this application.
I'll do it. I'll make a motion to continue the application ZBR-23-03 to a date certain of March 14th, 2023.
I'd second that.
We have a second, all those in favor?
Aye.
Opposed? Motion to adjourn,
I'll make a motion to adjourn.
second?
Second.
Thank you.
All in favor?
Aye.
Thank you, sir.
Thank you, sir.
Good luck. No, we're gonna do that next meeting. Well, we figured we had 3.